Discussing what a power of attorney is. How do you authorize someone to conclude a legal act on your behalf? So you do this by way of a power of attorney, which is a formal document by which a person or you empower or authorize someone else, like an agent, an attorney, or yes, to conclude a juristic act on your behalf. And what is a juristic act? It is whereby legal relationships are created which has legal consequences. For example, to sell your business on your behalf. So a power of attorney is not a contract, but rather it is an expression of will by the principle that the agent shall have the power to act on his or her behalf. So basically it is just a written consent document that someone will have the power to act on your behalf. So you can sign a power of attorney which not only empowers the agent to act but also indicates to third parties or other parties of your will to be bound by acts performed by this agent. So whatever this person signs on your behalf, you will be legally bound by such agreement. So a properly authorized agent who validly enters into a contract on behalf of another is therefore protected from any liability arising from this contract. However, if the agent is not properly authorized, the principal acquires no rights and incurs no duties in respect of the juristic act, and the third party can hold that agent personally liable for breach of warranty of authority. And then a person who continues to act on an invalid power of attorney can be considered a fraudster, which exposes him or herself to legal disputes and claims which this person would not want for themselves. A general power of attorney allows an agent to make numerous decisions and perform variety of acts on behalf of the principal, including legal and financial activities. The capacity of the principal: in order for the power of attorney to be valid, the principal must have the necessary contractual capacity. So in South Africa, the law of agency is based upon the principle that an agent cannot do that which his principal has no capacity to do himself. So in other words, you cannot authorize someone else to perform acts that you cannot or do not have the capacity to perform. For instance, if you are a minor, you cannot sign a power of attorney where another minor is your agent. So therefore, a person who cannot understand the nature and consequences of granting a power of attorney cannot validly execute such power of attorney. The principal must be mentally competent at the time of signing the power of attorney in order to fully understand the nature and extent of the powers being transferred. Furthermore, you are required to be 18 years or older to grant a power of attorney. So, let's talk about the agent, the person who is given the power of attorney. So the person who gives or receives the legal permission to act and decide on your behalf is called the agent, or otherwise the grantee, or the attorney in fact. Anyone over the age of 18 can be granted a power of attorney by principle, as long as the agent is competent and trustworthy to make financial and legal decisions and sign legal documents on the principal's behalf. An agent can be a trusted friend, competent, relevant attorney, or a financial advisor, to name a few. So what are the reasons for entering into a power of attorney? A power of attorney does not necessarily imply that a person is unable to make decisions. It just means that certain circumstances or specific reasons compels you to make use of an agent to get things done. There are various reasons or circumstances for a person to decide to execute a power of attorney. For example, immigration, South Africans often leave the country before all their financial businesses and other issues are concluded. To ease and facilitate the processes, a power of attorney is signed to allow someone still residing in South Africa to take care of the outstanding matters. After all, it is much easier to sign a document in South Africa than to send it to a foreign country, sign it and send it back. When you are out of a country or out of the country for an extended period and need someone to manage your legal financial matters, such as dealing in property, you are required with the expertise to assist you in situations such as managing your money and bank accounts, buying and selling mortgages and managing properties, handling tax queries and filing tax returns, entering into contracts, settling claims, and planning your estate. When you need an agent to perform a specific task or tasks on your behalf, for example, collecting your pension, paying your bills from your bank account, renewing a vehicle license. If you are temporarily incapacitated due to illness, injuries, or hospitalization and are unable to perform daily tasks. Commonly, a power of attorney is also signed for elderly people who are compelled to grant power of attorney because of increasing frailty, too weak to physically sign documents. A principal or you are not allowed to give power of attorney to a person to draft a will or initiates divorce proceedings on your behalf. So what are the requirements for a valid power of attorney? A power of attorney is by nature and form a written document signed by both the principal and agent. The power of attorney must clearly describe and identify the principal and agent as well as the extent of the powers granted to the agent. No document, procedure, form or formally described for a power of attorney to be valid. Although it is advisable to have a power of attorney drawn up professionally to describe powers accurately, and the witnesses are not allowed to gain any benefits from the power of attorney. A principal can cancel his or her own power of attorney at any time, but it is important to note that there are circumstances where power of attorney terminates automatically if and when you die and an executor is then appointed, you become insolvent and your estate is sequestrated, you become mentally incapacitated in the sense of being no longer able to make your own decisions for whatever reason. Example, a stroke, a coma or an accident, mental illness, dementia, Alzheimer's, general age-related diminishing capacity, and so on. So it seems, so the last scenario of you becoming mentally incapacitated, most people are unaware of because it seems illogical for a power of attorney to lapse when it is needed the most. But that unfortunately is the law of South Africa. An agent can do what the principal can do. So if a principal loses legal capacity, the power of attorney immediately fails, or as a Department of Justice document neatly puts it in South Africa, the power of attorney remains valid for as long as the principal, who is you, is still capable of appreciating the concept and consequences of granting another person his or her power of attorney. So in a nutshell, that is power of attorneys in South Africa, how they work, why you would need them, when they would terminate, and how to validly set up or draft a power of attorney. Stay tuned for our next video. Click the like button, subscribe to our YouTube channel.